Hi, everyone. Welcome. We're just waiting for people to continue joining us from the waiting room. Okay, I think we'll just give a few more minutes and then we'll go ahead and get started out of respect for everyone's schedule. All righty. Welcome. Good afternoon. And welcome to the League of Women Voters of Illinois' virtual briefing on the Illinois Pretrial Fairness Act. My name is Allison Hout, and it is my honor to serve as the president of the League of Women Voters of Illinois. Today, we are pleased to be joined by a distinguished and talented panel of experts to lead us in an exploration of the importance and the many benefits of pretrial justice reform. As we look forward to the successful implementation of our new law in Illinois, your choice to be educated in these matters will make a difference. We call on each of you to use today's briefing to become informed and to share what you learn with friends, family, and colleagues. When you leave this event today, you have the opportunity and truly the responsibility to help create an informed community. The League of Women Voters of Illinois knows that informed people are the people who become civically engaged, are the people who learn about the issues that they care most about, the people who follow through and vote, and the people who vote informed. So with our midterm elections upon us, let's advance today's energy into the success of the Pretrial Fairness Act and to successful elections with high voter turnout. Successful elections are how we get to have leaders who bring us things like the Pretrial Fairness Act, who listen to the voters and follow through with what the voters care about. So we call on you to engage others on today's topic and also to vote and to vote informed. Please use our online Illinois voter guide as your one-stop shop for all election-related information. Make sure that our communities show up, activate, and engage to elect representatives who will follow through on the issues you care about, things like the Pretrial Fairness Act. And now it is my pleasure to introduce Laura Davis, a distinguished member of our League of Women Voters of Illinois Issues and Advocacy Committee, who will introduce our speakers.
Thank you, Allison. Good afternoon again. Welcome to the League of Women Voters of Illinois webinar on the Pretrial Fairness Act. Today's program will focus on why and how we need to continue to advocate for the Pretrial Fairness Act, an important part of the criminal justice reform enacted in 2021. Our program today will begin with a presentation by Sarah Staudt, Director of Policy for the Chicago Appleseed Center for Fair Courts. Sarah will give an overview of the Pretrial Fairness Act and share its most important provisions. Then a panel will discuss the implementation of the Act and answer questions concerning its rollout on January 1st of 2023. So let us now turn this over to Sarah for her presentation.
Good afternoon, everyone. As Laura said, I'm Sarah Staudt. I'm the Director of Policy at Chicago Appleseed Center for Fair Courts. I'm going to share my screen here, always a little challenging. Hope everything is good. What I'm going to do today is I'm going to start us out. I'm going to leave as much time as I can for our amazing panel because I want to make sure we have a great discussion. But I want to ground us by starting with talking about what money bond currently looks like in Illinois, what the pretrial fairness does to change some of what our pretrial system will look like in Illinois, and some of the impacts that we hope that it will have. So let's talk about the effect of money bond in Illinois. There are 91 jails across Illinois' 102 counties, and more than 250,000 people are incarcerated in Illinois' jails every year. Most of them are incarcerated, the vast majority of them are incarcerated pretrial, and most of them are incarcerated because they can't afford to pay a money bond that is set by the court. So to talk a little bit about how the current system works. Right now, so today, before the Pretrial Fairness Act has gone into effect, the way that someone is processed through the system, just to give some grounding, is that someone is arrested and they go before a judge at a bond hearing. At that bond hearing, the judge has a couple options. They can release them on what we sometimes call an I bond or a recognizance bond, where they're able to go home without paying any money. They can also be totally denied bond after a hearing. But the most common outcome is that they're given a money bond, an amount of money that they need to pay in order to go home. And essentially, the question of whether someone is incarcerated pre-trial or whether they're released then turns primarily on finances, whether the person has the amount of money that they need to post, that the judge has said that they need to post to get out the door. Why do we care? So the Pretrial Fairness Act, as I'll go into, its primary goal is to reduce the number of people who are incarcerated pretrial in Illinois. So why do we care about reducing pretrial incarceration? Pretrial incarceration is, of course, the incarceration of people before they've been proven guilty of a crime. So it's incarceration before we have all the facts out on the table and before people have really had their day in court to look at what actually happened in the incident in question and whether or not they're guilty of what they're charged with. So we know that incarceration at this time has really serious justice implications. It's also incredibly harmful to people's livelihoods and to our communities as a whole. Pretrial incarceration is extremely racially disproportionate. Cook County, for example, is 25% Black, but almost 75% of the people in Cook County Jail right now are Black. And pretrial incarceration, even for a day, can massively destabilize people's lives. It causes people to lose employment. It can interfere with people's ability to keep their housing, to take care of their families, to make sure that their children have someone to take care of them. And so even just a day or a couple days of pretrial incarceration can mean that somebody comes home in a much more destabilized position than they were when they went into jail. And what that means is that there are long-term consequences. We know that not only are people more likely to lose their jobs if they are incarcerated pretrial, but that also in the long run, people who are incarcerated pretrial are more likely to plead guilty in the cases that they're charged with, and are more likely in the future to be arrested again. And so in that way, we're really shooting ourselves in the foot when we incarcerate people pretrial, because we're creating a system where we're destabilizing people's lives and increasing the likelihood that those same people come back to the criminal legal system in the future. So what I'm going to do now is do a principled walk through the Pretrial Fairness Act. So quickly, how the Pretrial Fairness Act came about. Chicago Appleseed is a member organization of two groups of organizations, the Coalition to End Money Bond, which is mostly a Chicago-based organization, and the Illinois Network for Pretrial Justice, which is a statewide network of organizations. And together, these organizations have been working for years to change the law in Illinois so that we have more pretrial freedom and so that money is not what determines whether someone is free. These efforts started, wow, almost a decade ago. But in 2020 and 2021, they were picked up very extensively in Springfield. And in January of 2021, the Pretrial Fairness Act was passed as part of a package that you may have heard of called the Safety Act. The bill was passed in January of 2021 with a 2-year delayed effective date, which means that we're just now coming up on the time where the law is actually going to be put fully into effect, which will happen on January 1st of 2023. So in just a little under 4 months. The law's primary goal, as I said, is to reduce pretrial incarceration, but it also reforms other parts of the pretrial system. It's really a full overhaul of the pretrial system so that at all stages of the time between arrest and conviction, people are treated more fairly, more justly, and we have fewer people spending time behind bars. So the first basic principle that shapes the Pretrial Fairness Act is that money should never be a determining factor in whether someone is free pretrial. This is, I think, what the bill is generally the most famous for. What the law does is it ends money bond throughout all of Illinois for all charges. This makes us the first state to fully end money bond, although New Jersey came very, very close in 2017, meaning that they have gotten rid of money bond for almost all charges. But in Illinois, once the Pretrial Fairness Act is in effect, there will be no money bond for any charge. And that's a really important step forward and makes Illinois a leader on this issue nationally. The second and probably the most important principle, which I'm going to spend some time on, that shapes the Pretrial Fairness Act is the idea that release should be the norm and detention the carefully limited exception. If that language sounds like legalese, it's because it is. It actually is drawn directly from a US Supreme Court case called US v. Salerno, in which the Supreme Court said, in general, for almost everyone, people should be released pretrial because they are presumed innocent. And we should only be using jail and detention in situations that are very, very carefully limited. The Pretrial Fairness Act tries to make this value a reality. It does that at a couple different stages of the system. The first stage of the system, where we increase the amount of release that we hope will occur under the Pretrial Fairness Act, is right when someone is arrested. Right now, when someone is arrested, they are almost always taken to a police station and then held overnight to see a judge the next morning. Under the Pretrial Fairness Act, police are required for lower level offenses, for nonviolent low level offenses, to ticket people on the street rather than taking them into police custody. Police still have the ability to arrest somebody if they pose a threat to the community or if they pose a threat to themselves. But we hope that the norm will be that people will be ticketed for low-level charges, which decreases the amount of time that people need to spend in custody, because just an arrest, even if you're released sort of as soon as possible, can take 12 or 24 hours. And like I said, that can destabilize someone's life. The biggest place where the Pretrial Fairness Act seeks to limit pretrial detention is in the question of who is actually going to be held long-term, meaning who's going to be held in custody until trial or until a judge decides to change their custody status. Right now, that happens based on whether someone has money. Under the Pretrial Fairness Act, there are two different things that the Pretrial Fairness Act does to limit the number of people who are spending the whole time until they are going to trial in custody. The first is that it creates what we sometimes refer to as a detention eligibility net, which is sort of a fancy way to say that for most people who are arrested, since most people are arrested for pretty low-level crimes, for most people who are arrested, release will be required when they appear before a court, unless they're already on pretrial release for something else. For a smaller number of people charged with more serious crimes, some crimes are eligible for the state, for the prosecutor to ask that that people be jailed until trial. The state's attorney needs to make a specific proffer and needs to convince a judge of one of two things: either that the person poses a specific, real, and present threat to the safety of another person, or that they have a high likelihood of willfully fleeing the jurisdiction. So the Pretrial Fairness Act both creates a set of charges that are not eligible for jail, and it also creates a standard that makes sure that even among people who are eligible for jail, only those for whom a judge can really say this person poses a danger or this person is likely to abscond, only in those situations can a person be held in jail. So this is sort of for visual folks, this is a flow chart of how the Pretrial Fairness Act works. After you're stopped by the police, you can be cited or released, or you can be arrested, charged, and booked. Even after you're arrested and charged and booked, in some cases, you can be released from police custody and appear before a judge up to 21 days later. For people who are held overnight, they will have what's called a conditions hearing the next day, where conditions of their pretrial release will be determined. That's also the hearing at which the state will determine, is this a person who is eligible for long-term jailing and who we want to jail until trial, and can file a written motion asking the judge to hold the hearing to address that question. If the state does not file that motion, the person is released either with or without conditions of pretrial release, things like electronic monitoring or reporting to a pretrial officer. Those are the kinds of conditions I'm talking about. If there is a detention hearing, it's held within 24 to 48 hours after that first conditions hearing, and it can result in one of two outcomes. Either the judge says, no, I don't believe this person poses a specific real and present threat to another person, or I don't believe this person poses a high likelihood of willful flight, in which case the person is released, or the judge can find that they agree with the prosecution and the person can be detained. If the person is detained, they're detained without bond, which means the only way that they're released from custody after that point is if the judge reconsiders their decision, which can happen at any court date. But someone can't sort of suddenly leave jail by paying an amount of money the way they currently can. The third principle is that accused people should be viewed holistically, and that no single factor should be used as a substitute for individualized decision making. And we focus on this idea both in the question of whether someone is going to be jailed and in the question of what conditions of release they might be placed on them when they are released. One of the biggest things that the Pretrial Fairness Act does in this arena is it limits the role of risk assessment tools, which are algorithms that take information about a person and then spit out a risk score. It limits the use of those risk assessment tools in decision making by basically making sure that defense attorneys have access to all of the information about the tool and have the ability, if necessary, to challenge the risk assessment tool criteria. And so we hope that that will really add accountability to some of these tools, so that we don't end up we don't have a situation where an algorithm is the sole determination of whether someone is held pretrial or whether somebody is given certain pretrial conditions. And the Pretrial Fairness Act actually specifically forbids that from happening. The fourth principle I want to talk about is sort of basic, but it's that courts should help accused people attend court hearings, and they should restrain their freedom as little as possible while they are legally innocent and awaiting trial. The Pretrial Fairness Act does this in a couple ways. The first is that it reforms the warrant process. It gives judges a way to respond to failures to appear in a court other than immediately issuing an arrest warrant where someone is going to be scooped off the street if they've missed court for whatever reason. Instead, if the judge wants to, they can issue a notice to appear to basically notify someone, hey, you missed court, come into court within 48 hours of getting this notice. And if you do, we will remove the failure to appear from your record and move forward with your case. The Pretrial Fairness Act also reforms some things about electronic monitoring programs. Electronic monitoring programs are any program that requires someone to wear or carry a device that tracks their location and restricts their movement in some way. In most cases in Illinois, it's a house arrest program, meaning somebody can't leave their house without specific permission. Actually, these provisions of the Pretrial Fairness Act are already in place The Pretrial Fairness Act requires that people be able to leave their house to just fulfill basic life activities, buy food, do their laundry, things that are necessary to live. And also requires that, and also makes some other changes to the program to make sure that people are not being charged with new felony charges for minor violations, for example, being 20 minutes late coming back from work. So there are some other changes as well about electronic monitoring. I'm happy to answer questions about that. For the sake of time, I'm going to move on from EM right now, but feel free to ask questions about it if we want to talk about it later. The fifth principle I want to talk about is the idea that people released pretrial should be treated fairly if they violate the conditions of their pretrial release. The law reforms the process for determining whether someone has violated pretrial release and requires that there be a finding that the person has willfully violated the terms of their release before they can be incarcerated. It also says that that for most violations, for minor violations that aren't criminal, things like missing court, things like failing to meet with your pretrial officer, incarceration all the way until trial is not on the table. Shorter term incarceration is possible and is a possible sanction that a judge can use, but the law pushes judges to use non-carceral responses to low-level violations, so that we don't have people who have, often because of poverty or just life circumstances, have been unable to meet the conditions of their release, suddenly finding themselves in jail because of those circumstances. And the last principle is that pretrial practices should be transparent and accountable. The law creates a statewide data collection and publication process, which there's been a board meeting about this now for about a year, a little bit longer, actually almost a year and a half now. And the goal is basically to standardize the way that we collect data about pretrial conditions across the state, so that we can actually know what's going on, who's being jailed, who's not, what kinds of conditions are being set upon people's release, and all sorts of other information that right now is pretty hard to aggregate across the state. I also want to talk about gender-based violence specifically with the Pretrial Fairness Act. Pretrial Fairness Act is, as far as we know, maybe the first major piece of sort of criminal legal system reform legislation, like a big package like this, that has moved around the country with support both from the criminal legal system advocacy community and from anti-domestic violence and anti-sexual assault victims advocacy organizations. Networks representing over 60 of these organizations throughout the state helped put together the Pretrial Fairness Act and had input into what it said. And there are specific protections for domestic violence and sexual assault victims in the bill. The bill makes it easier to get protective orders at any court date. It increases the amount of time that states' attorneys have to confer with victims before a jail or release decision is made, by creating that gap of time between a first appearance and when a detention hearing is held. It recognizes domestic abuse as a form of violence that should be considered in the pretrial release and jail decision. Throughout the process, it creates better victim notification. And there's also a domestic violence pretrial practices working group that's meeting right now to make additional recommendations of how the pretrial system can better serve the needs of victims of gender-based violence. And with that, I think I'm going to go ahead and let our panel start. Thank you all so much.
Thanks, Sarah. Our panelists joining Sarah are Sharone Mitchell, Cook County Public Defender, and Mallory Littlejohn, Legal Director of the Chicago Alliance Against Sexual Exploitation. And my first question is for Sharone. Welcome, Sharone.
Hey, how you doing?
Very well.
On the hot seat early on. That's okay.
Yeah.
We're used to it as public defenders. It's okay. I'm ready.
Okay. All right. From your perspective as a public defender, how do you think the Pretrial Fairness Act will improve the criminal justice system?
You know, I think the Pretrial Fairness Act has incredible potential to have significant impact and significantly improve the criminal legal system. I think it's first important to really consider where we're coming from. What does the system look like right now? And this is a system that often values a person's access to money over any evaluation of risk, whether that's risk of flight or risk of committing more harm. The idea that we are valuing money as a top variable is an extreme problem. We have a system that strips tens of millions of dollars each year from communities, typically Black and Brown communities, typically Black and Brown women who are essentially paying ransoms for their loved ones' freedom. These are loved ones that have not been found guilty of any offense. We have a system that is really two-tiered, that folks with access to money can buy far greater results in the criminal legal system compared to those that do not have access to money and who actually incorporate the vast majority of the system. And we have a system that encourages, through a patchwork of laws, a system that makes quick decisions based upon minute-long hearings, and those minute-long hearings being some of the biggest decisions that you can make in a criminal legal case. So for me, I start with, what does the system look like now? And if we can make changes to the system, we can have far greater impact. And what that means to me as a public defender is better decision making. We understand that there will be decisions that won't go our client's way. We believe in the presumption of innocence. We believe that individuals should have a fair trial. But the reality of the situation is that current system, it isn't a bug, it's a feature that forces our clients into pretrial incarceration because they are poor. And we believe that any effort to take that out is a good. Now, with that said, the work is not done yet. And we know there are two kind of big things. One that we're going now, that's implementation. This is a sea change when it comes to how the criminal legal system makes decisions. So it has been a lot of work ensuring that we are ready on January 1st to run a smooth system. But I think also there is the fear of backlash and the fear of rollbacks. And we could talk about that threat in a minute. But thank you so much for having me. And I really, really, really appreciate the opportunity to talk about this bill. This law, excuse me.
Thanks, Sharone. Mallory, some members of the law enforcement have claimed that the Pretrial Fairness Act will be bad for people who have experienced violence. Why do you believe that the Pretrial Fairness Act actually prioritizes survivor safety?
Well, first, I would like to thank you all for having me here. I'm really excited to be able to speak about an issue I'm quite passionate about. The current system, like Sharone said, is not working. It is not set up for victims. It is not set up for survivors. Because of this fact, victims are not prioritized or thought about, and oftentimes not even heard when making the decision about release. The thing that is most important in so many of these cases when we're talking about release of somebody who is constitutionally presumed innocent is money, and not survivor safety, not victim safety. And that is why I am very excited for the Pretrial Fairness Act to be implemented in January. It allows for safeguards and creates specific questions that prosecutors and judges will be accountable for in order to make sure that victims and survivors are being heard, are being acknowledged, and that their safety is being put first.
So just a little follow-up. So are you actually saying that the current system is bad for survivors?
It is not currently set up for survivors. I like to speak in statistics because, numbers are great. Currently in Chicago, about 80 to 90% of police reports regarding sexual assault, for example, go nowhere. They don't end up in arrest. They don't end up in charges. They don't even end up with survivors meeting with the detective. And so it's often really frustrating for me as an attorney that represents victims inside of the criminal justice system to hear people inside of the criminal justice system that disregard 80 to 90% of police reports then come and tout, what about the victims? What about the victims? And so I am here to say the Pretrial Fairness Act actually answers the question, what about the victims, in a way that the current system does not.
Thank
You
you.
mind if I jump in here for a second?
Sure.
I think one of the important things to think about as well as this bill was crafted, as it was actually drawn up, groups who are representative of survivors of domestic violence, who are survivors of sexual violence, made real edits to the bill, had a real influence on how the bill was actually crafted. You know, typically in the advocacy community, you see written piece of legislation being passed around and groups having the opportunity to sign off on it. That is one really important type of engagement, but it takes it to a whole different level when you're empowering groups that have the ability to actually make changes to the bill, to actually add things to the bill that come from their perspective. And I think that's what you saw with this bill. You saw, and Sarah can actually speak to it better than anybody in the state, you saw groups adding in notice requirements, adding in very specific structures into the bill. So it's not about just groups signing off for the bill and taking a completed piece of legislation and saying, oh, I like it. It is actually having the power to make changes. And that's why I think what Sarah said is so exciting, that you have this piece of legislation that has the sign off from two sets of advocacy groups that people try to pit together oftentimes, but have actually come together to put together a piece of legislation that we believe will bring both groups' interests far ahead.
Thank you, Sharone. Sarah, do you want to add anything into that?
I'll just add that I really appreciate, and this is in part, there's major shout out to the Cook County government and to the statewide implementation team on this. Victims advocacy groups have also been really well represented in our implementation spaces. So in the working groups around the state, there's been real conversation about what does this bill look, what does the world of the Pretrial Fairness Act, you know, the post January 1st world look like for survivors? How can we make it better? And that's incredibly valuable because ultimately, you know, the criminal legal system is a space with a lot of different interests and a lot of different stakeholders, and it's really by working together across those divides and across, or what are often considered divides, that we can create a system that actually works.
Thank you. Sarah, the next question actually is geared toward you. Some people are very concerned about releasing certain defendants that they worry will perhaps commit another crime. Do you think requiring electronic monitoring is a good compromise between perhaps detaining someone in jail or releasing them without conditions? And why or why not?
So I think the most important thing to frame here, and I'm going to do numbers, just like Mallory said, I love numbers, is to talk about, all right, when people are released from jail, how many of them actually go and commit new crimes? And the answer is an incredibly small number of people, and particularly an incredibly small number of people go on to commit violent crimes, which is, of course, what people are the most worried about. The vast, vast majority of people will both return to all their court dates and not be rearrested while they're awaiting trial. And that's true even if they don't have pretrial, you know, supervision and other kinds of surveillance over them. People succeed just fine for the most part without anything other than their freedom. We need to be clear that something like electronic monitoring isn't a service that we're providing to people. It's another form of incarceration. So, you know, this is an issue that's primarily a Chicago issue in Illinois, but we do have electronic monitoring programs around the state. But in Chicago, we have one of the largest pretrial electronic monitoring programs in the country. It's also one of the most restrictive programs. And we have people who are incarcerated in their homes, unable to leave except for very short periods of time throughout the week. And it makes it incredibly difficult. It has many of the same harms as incarceration does. It makes it incredibly difficult to find work. It makes it hard to connect with your families. I mean, if you live one place and your family lives somewhere else, it can be very, very hard to connect with your families and your kids and anybody else. It makes it very difficult for people to successfully participate in their communities. And it also means that it increases the risk that people are going to be reincarcerated because there are technical ways they can violate their electronic monitoring. Even people we know about people who have been reincarcerated for taking out the garbage because it violated the terms of their electronic monitoring that said they had to stay within the walls of their house. And that is a massive waste of life and resources. So we really need to be clear that electronic monitoring is another form of incarceration and need to be using it as sparingly as possible.
Okay, thank you. Sharone or Mallory, do you want to contribute on that? There certainly is a lot of electronic monitoring in Cook County. So any comments you want to make on that?
I'll say I definitely agree with what Sarah said, but I think it's important to, I can see people who are listening to this webcast and say, well, I get that. I hear what the words that you're saying, but every time I turn on the news, I'm hearing story after story of somebody who is, been arrested 10 times and 15 times and 20 times. And I think it's important for us to really acknowledge the fact that we are in a really difficult time when it comes to coverage of the criminal legal system. If we have, let's say, those numbers that suggest that, 1% of people are rearrested for a new crime. Well, the reality of our system when it comes to how we receive news is that you'll hear about 99% of that 1%. And the other reality is of those 99% of people that don't do anything wrong, that come into court and handle their case, well, you'll hear 0% about that. So all of the stories you're hearing about the criminal legal system, right, is these instances which are outliers. Now, they're serious, and they're something that we should be working to eradicate. I don't want to act as if even small incidents of harm aren't important. They are. But as we think about what the criminal system, justice legal system looks like, it's important to note that we are being force-fed stories of failure, and the typical story, right, is hidden from public view. That's why things like court watching are so important, because you get an opportunity to actually go into the courtroom and actually see what happens on a day-to-day. It is so difficult to tell these stories about the criminal legal system when we are relying on just man A committed offense B at place C. I think it's also important to note, and of course, I'm the public defender here, oftentimes the criminal legal system treats allegations as the truth. And I think that this region has a long history of teaching us that that may be not the best thing, and that sometimes we need to be talking about kind of what happens after arrest and whether those charges are actually truthful.
Well, that just really leads me into the next question, Sharone. Very good setup there. But for all of you to talk about, some states' attorneys and sheriffs have expressed concerns, and we've seen the political ads that suggest that criminals will be loose on the street when the Pretrial Fairness Act goes into effect. So how would you calm these fears? Not everyone's going to court watch, but
I can jump in, or anybody can jump in.
Go for it. All of you can continue.
I will say that is a great question, and I don't have a great answer. And here's the reason why I don't have a great answer. You have a group of individuals who are, quite frankly, committed to just lying about the Pretrial Fairness Act. Just this morning, I was watching a minute-and-a-half clip of an individual that was running for federal or for elected office. And he had 1 minute and 30 seconds to talk about the Safety Act and the Pretrial Fairness Act. I wrote it down. every single sentence that he said was untrue. Every single sentence he said was untrue. When it comes to we can disagree about whether we should end cash bond or not. You guys know where I'm at on the situation, but we have gone far past kind of real debate, and we've gone to a place where individuals believe that there is political gain in lying about what this bill does, that they believe that they can gain seats or gain office if they tell stories about what this legislation actually does. So I will say, I feel kind of like we're on kind of the losing end, because I think that we as advocates for this bill or this law aren't willing just to lie. I'm not going to lie to you and say that this bill will end harm in the state of Illinois, in the county of Cook, in the city of Chicago. We will still have problems with the criminal legal system, both on the unfairness side and the accountability side. But what I can say is that this bill is a step forward, and you have people out there that have high office, who you would think have a duty to the truth, quite frankly, just telling lies about what the law does.
Yeah, I mean,
oh, sorry.
Yeah, that's exactly what I was going to say. I mean, I think, I explained it, during my presentation, sort of how the bill functions. But, one of the most pervasive lies is a various shorthand for sort of, I will not be able to jail anyone because I won't have bail available to me after January 1st. And that is just, I mean, it's so radically, patently false that it's hard to even engage with seriously. But, as I said, Pretrial Fairness Act has a mechanism to allow jail in certain circumstances. And that mechanism is focused on safety, and it's focused on making sure that people come back to court and do not flee the jurisdiction. And it's not focused on money. We also have to remember, and I think it's incredibly important to remember, that the current system is not guaranteeing anybody's safety. Money bond is not a safe system. Money bond has not kept people safe. Money bond, and I'll let Mallory talk a little bit more about that maybe, but money bond is not a system that is doing what it's being claimed to be able to do, frankly. So what the Pretrial Fairness Act is trying to do is create a more rational system, one that's based on questions of risk, right? And ones that's based on careful, reasoned decisions about individuals and what should happen in individual cases, and not broad sweeping ideas or decisions made solely on the size of someone's bank account.
Yeah, I agree, Mallory. And also when you answer to that, because there have been a lot of comments about how it's going to impact domestic violence, and curious, were gender-based violence, was that part of also involved? Okay.
Yeah. I was reading a story in the news today about a young lady who called the police on her boyfriend and got the boyfriend to leave the apartment. And the police were coming in as he was leaving, and he shot the officer, and the officer is severely wounded. That sounds like a great case for that particular individual, who clearly was a threat to their partner and law enforcement, to remain incarcerated. But there was bail, there was cash bond set on that case, which seems like a wild thing to have happened based on what I just told you. Additionally, there were at least 6 previous police reports made regarding domestic violence in this particular individual. Logically, I don't understand why this individual was given any cash bond. Under the new system, that won't be an option. Everything that we just talked about, the previous police reports, the threat to law enforcement, the threat to the specific victim in the case, will be taken into account when deciding if someone should be detained or not. If that individual is able to post that bond, and like Sharone said, it will probably be from their mother or their partner who mortgages a house or comes up with that money, they will be back on the street. And so cash bond does not protect anyone. Cash bond does not equal safety. And that is just an inaccurate statement that I think goes directly towards fear mongering. It's really scary when you don't feel safe going outside, when you see all of these stories in the news, but it's just not connected to cash bond.
You know, I've heard, that's such a great point, Mallory. You know, I've heard stories of the Pretrial Fairness Act banning judges' ability to issue warrants. I've heard stories about the Pretrial Fairness Act inhibiting police officers' ability to arrest peeping toms. I've heard stories about the Pretrial Fairness Act meaning that every single person accused of murder will automatically be released on January 1st. Listen, like any piece of legislation, people will continue to come back to this issue. That's why Springfield has a big, shiny capital for people to create new laws, right? But the fact of the matter is there is so much misinformation about this bill. It is just like what we're seeing on a national stage when it comes to misinformation. It is no different. And I really feel sorry, quite frankly, for folks that are trying to make a good decision about what they should be supporting, because they are getting an influx of lies about what this thing does. And I would just encourage people to take a step back and really think about the status quo. What are we doing right now? You know, in one of these stories, there was, all these individuals, right, who would be released on January 1st. And we can go back and forth about pretrial incarceration and its effects. But I thought one thing that was really interesting is that all of those individuals had a cash bond. So if they had the amount of money available, they would have been able to leave the jail. Now, again, I'm not making a statement about these individuals about whether they should be in or should be out. I'm not a person that loves pretrial incarceration as wide as it is today. But let's be clear. You have individuals saying, oh my God, these people are going to be released on January 1st. They're not going to be released on January 1st because of the bill. And also, we live in a system where if they had the amount of dollars, they would bond out right now. What are we doing here?
Yeah, well, I have one more question I want to share with you. We want to get some questions from the audience then. But the last question, is there a concern that there will be legislative challenges in the veto session to this bill?
Yes, this is the basic answer to that question. We know that during veto session, there's going to be a lot of discussion of the Pretrial Fairness Act. And some of that is really important discussion. This bill had a 2-year implementation period for a reason. We needed to sort of kick the tires, right? To make sure that everything about the bill was working correctly and made sense. And there are things that need to be changed about the bill to make sure that on January 1st, it's ready to go. And, is, for example, entirely internally consistent on legal standards, things like that. Those are changes that are very important to get made. There are also people who are trying to repeal the bill. And some of them are trying to repeal the bill outright, and others of them are trying to repeal the bill with 1,000 tiny cuts, right? Stripping away parts of the bill until we end up with a system that, and the risk here is we could end up in a system, if we were to gut the Pretrial Fairness Act and still get rid of money bond, we could end up in a system that increases pretrial incarceration. Because if we can, for example, if a huge number of people are eligible for jail and judges are jailing all of them, and their money bond no longer exists, we could end up in a worse situation than we were before the bill passed. That's a real concern. So we have to make sure that our legislators are held to the values of why this bill was passed. Because those values are essential in terms of making Illinois a safer place.
Well, thank you. Okay, so we're going to move to some questions from the audience, and we have Beverly Graham from the Oak Park River Forest League, who will be asking those questions. So Beverly?
Yes, the first one is, for which offenses can a prosecutor ask for defendant's incarceration pretrial?
Essentially, the answer to that question depends on why the prosecutor is asking for detention. For cases where somebody is, the worry is that they will flee the jurisdiction, essentially any serious crime, anything that's a class 3 or above is eligible for jail. In safety cases, questions about safety, the basic categories are non-probationable forcible felonies, which is a fancy way of saying very serious violent crimes, all gun charges, all sex charges, all domestic violence charges, all violations of orders of protection, all trafficking charges. That, Sharone, I think that's all my categories. So those are basically the categories of charges where safety is going to be talked about.
Did you say gun charges as well?
Yeah, all gun charges.
Another person wanted to know if this recording will be available after the end of it, and yes, it will be. Someone else asked where they can get statistics, and that a link was sent for those statistics to be accessed. I'm not sure I understand. Does the law say that the individual must pose a threat to a specific person? If there is no specifically identified person they are a threat to, then does that mean they are released, even if they pose a generalized threat, say, history of them perpetuating gun violence in the community? You want me to read that again? It was kind of, no.
Sarah, do you want to handle it or do you want me to handle it?
Go for it.
So yeah, there's been kind of, I think this, I don't know what to call it, like meme or idea that a person must be identified before a person can be detained. And that is just not true. All of the information that a prosecutor can use now, information about a person's history of harm, information about kind of what they've done in the past will likely be used in what we're calling these detention hearings. What the standard is essentially is you've got to make an argument that goes to suggest that a person would be a harm to a person or any persons. It's not like you have to name that person and that person has to come in and testify that they will be harmed. So that's another one of those misconceptions that we're hearing. Now, there's no doubt we want to move away from a system where you can just get up and say, this person is a danger to society, and that's all you have to say, and they're detained, right? But all of that evidence that you described in that question can be used to consider whether that person will be detained or not. And again, it is important to think about the status quo. The status quo, you can make all of those arguments, and in more than half of the cases, there is an amount of money that is set. And if that person can make that amount of money, they're able to be released.
Okay. Next question. Isn't the real issue for the criminal justice system is the loss of money usually collected from the accused? Our county here in Champaign County stands to lose over $3 million a year. What impact financially will the Safety Act have on the counties?
That's a really good question. And it's something that we've also been hearing a lot about. To a certain extent, there's a misconception. There was a study done by the Civic Federation about how much money is actually collected from bails. So obviously, bail money, counties have to give back, right? They don't keep all of the bail money. They do keep 10% of it. Those revenues are not a major impact on most counties' budgets. There are some exceptions out of the 102, but for the most part, that's not really where the money is coming from. Where the money is coming from is that basically what our courts are doing is taking people's bond money and then taking out of that bond money at the end of their case fines and fees that really, by all rights, should usually be waived and not assessed, because most people who move through the criminal justice system are indigent and can't afford to pay them. And the bond money isn't coming from the people who are moving through the system, right? Usually it's coming from their grandmas and their aunts and their communities. But the system is essentially garnishing that money to pay fines and fees that are assessed against the defendant. There is going to be I think it would be ridiculous to say that there isn't going to be some revenue loss on that side of the ledger. But we also have to remember savings. The goal of the Pretrial Fairness Act is to decrease jail populations, and jailing people is one of the most expensive things we can do. It's certainly the most expensive way we can treat someone pretrial. It costs $147 a day to jail someone in the Cook County Jail, which is millions and millions and millions and millions of dollars a year. And so as jail populations decrease, we're going to see savings on that side of the ledger. And the challenge for counties is going to be to make sure that those savings make it into the court system if that's where they need to be. But we really have to remember that when costs are talked about, people are not talking about how much the current system costs, particularly in terms of how much jailing people costs.
I think one thing I would add to that question as well, just one more dynamic, is that $3 million came from somewhere. And typically it came from the poorest parts of our communities. And there is a down the line impact to taking that money away from communities, both in terms of that family being able to thrive, but also how that family and that community reacts to that loss of money. Even when the money has been given back 90%, when you can't make your rent, right? When you can't pay your mortgage, right? When you cleared out your savings, right? What effect does that have on that community, that family? And what does that person now need to do, right, to make up for that loss of wealth? So I think we can think about it as kind of insiders, as system players, and say, what will the criminal justice system or criminal legal system do without that money? But I think we need to also be asking ourselves a question: what have families had to do without that money? What positions have they been put in, having to pay essentially what is a ransom, right? There's plenty of evidence from fancy criminologists and statisticians that suggest that when a person is detained pre-trial, they face far greater risk of being incarcerated in prison and serving longer prison sentences. But the fact of the matter is, families already knew that. And families already knew that it was worth risking everything to get their loved one out of jail. And as a public defender, as a line public defender, one of the toughest things I had to deal with was having conversations with parents and grandparents and sisters and wives. I know that Sarah can tell these stories too, about whether they would pay the rent or whether they would spend their last dime to bail that person out. And I think that loss of money had real effect on Black and Brown communities. And I'm very excited to see a world in which those dollars will not be siphoned out of the communities that can least afford that loss.
Thank you. There are no more questions, but I would encourage people to look in the chat for some links about outcomes, information about outcomes. And that's it for this side.
Okay, well, thank you. I just have to wrap up here, but I have one more question I wanted to ask Mallory that was here regarding what would you say to women victims' rights groups that oppose the Pretrial Fairness Act?
That's a really good question. I have a lot to say to them. I understand why. I absolutely understand why, especially after we had the conversation today about the fear mongering that is going on. It makes so much sense why people, especially victims and survivor groups, would oppose it. But Sarah can attest, Mallory personally was at the table. Other members from our organization were at the table. And we had to have some really tough conversations about some things. There was a lot of education that went on. Illinois has some of the best laws in the country related to victims' rights. And it was my personal goal, and I think we achieved it, to make sure that the Pretrial Fairness Act considered some of those laws, and that the people at the table, like Sarah, understood how those laws actually work every single day. As someone that has stood with many survivors at 26th in California, at the felony courthouse, and talked to prosecutors, seeing the way judges talk to the survivors, seeing how the bond system works, this is going to be a better system for our constituents. This is going to be a better system for us. This is going to be a safer system. And I think, like Sarah said earlier, there's still going to need to be some tweaks and some changes. No law that gets changed to this large effect gets passed the first time where everything is perfect. We're here to learn, and we're going to make those changes. But the fact that the DV folks and the gender-based violence folks are at the table for implementation, we're at the table for drafting, and will continue to be at the table, I think should give the opposers so much comfort in what the future is going to look like.
Okay, well, thank you both. Thank you all. That was wonderful. And I know I've been involved with this, but I learned something every single day. So I want to thank everyone for and leave you with some action steps. So first, let's contact your legislators. Let's use the action tool that's in the chat or right here on the screen to contact your legislators and tell them to stand strong on the Pretrial Fairness Act. By entering your information into the tool, you can contact both your senator and representative quickly with one message, and share the tool with your friends and family and ask them to do the same. Second, please sign up for the Illinois Network for Pretrial Justice newsletter in order to stay up to date about ways to support the Pretrial Fairness Act. And that link is also there on the screen. And if you don't get the, well, we're sending them out, and this will be recorded. So third, please save the date. On November 16th, people from across Illinois will come to Springfield for a lobby day. There will be a rally, and those attending will be talking with legislators about the importance of defending the Pretrial Fairness Act. Registration will be available later this month. And finally, thank you to our panelists, Sharone, Mallory, Sarah, for sharing your insights with us today. And thank you, everybody in the audience, for staying informed and engaged in advocacy. Your voice does make a difference.
Thanks, everyone.